Do you have a property that you have sold and the new purchaser requires vacant possession for their own use? Or do you have a property that is tenanted and you want to move into it, but you don't know where to start? Over the next few minutes, I'm going to provide you with some information on termination of tenancy for the landlord or new purchaser's own use. Because the process can be rather overwhelming, I have put together a free cheat sheet that you can follow. Drop me a line and I will send it to you. No email or opt-in of any kind is required. This is my gift to you for watching this video. For those of you who don't know me, my name is Bita Delisi. I am a licensed paralegal with a background in real estate and property management. I'm also a landlord and the owner of Stonegate Legal Services. I have helped hundreds of landlords with their tenancy matters, and I want to help you with yours. In this video, we're going to discuss the N12 Notice of Termination of Tenancy for the landlord or new purchaser's own use. The N12 can be served from a landlord to a tenant if the landlord, their immediate family member, being their child, parent, or caregiver, or if the property is sold and the new purchaser or their family member, being their child, parent, or caregiver, require possession of the property. It has a termination date of 60 days. However, the tenant still does not have to move out. We're going to discuss that in a minute. However, the N12 has certain requirements that must be met whether or not the tenant moves out. One of the requirements is the compensation. Compensation in accordance to Section 48 of the Residential Tenancies Act must be paid to the tenant on or before the day of the termination in the notice, whether or not that tenant moves out. It must be equivalent to 1 month's rent. A declaration must also be signed and submitted to the Landlord and Tenant Board from the person who says that they're going to be moving in, with reasons behind why they require possession of the property. Supporting documentation must also be submitted to the board. For example, an agreement of purchase and sale if the property is sold, a doctor's note if a caregiver is going to be moving in, a letter of employment if the landlord wants to be close to their employer. These are documents that also must be submitted to the board so that the board can issue a termination of tenancy order. Per the new Bill 184, landlords must also disclose of any previous N12s that they've served on the property that they want to serve this one to, or of any past properties that they've served N12s. They must also disclose the address of the property and the name of whomever is going to be moving in. On the second page of the N12, it tells the tenant, if you don't agree with this notice, you don't have to move out. So, although this is a 60-day termination notice, the tenant has the right to contest the notice, which means that the landlord must file the N12 with the Landlord and Tenant Board by way of an L2 application. Upon receipt of the L2 application, the board will then issue a notice of video or telephone hearing. All parties to the hearing must attend. If you don't attend your video or telephone hearing, the hearing will resume without you and you will not receive a favorable outcome. If you don't attend, you must also have a legal representative who will attend on your behalf. Remember, the tenant has the right to contest the N12. Usually tenants contest the N12 because they don't believe that the landlord is going to be moving in, or they don't believe that the new purchaser is going to be moving in. However, bad faith can only be proven once that tenant has moved out. The tenant can bring forward a T5 bad faith application against the former landlord or the new landlord through the Landlord and Tenant Board and request certain remedies. Some remedies are an order to pay a fine into the board, rent differential between the former unit and the new unit times 12 months, basically any other out-of-pocket expenses that tenant has incurred as a result of being served that N12 notice, up to $50,000. The board has a test to bad faith. There are 3 crucial questions that the Landlord and Tenant Board asks in order to determine whether or not the N12 was served in bad faith. The first question they ask is, did the tenant rely on the N12 in order to make a move? The second question is Is there an advertisement of the rental property? Meaning, has that landlord put up an advertisement on the Toronto MLS or Realtor.ca asking for more rent? And number 3, the trigger question is, did the person who was supposed to move in actually move in? The N12 process can be a bit overwhelming. Again, because the process is rather overwhelming, I have put together a free cheat sheet that you can follow. Drop me a line below and I will send it to you. There's no email or any opt-in of any kind that is required. This is my gift to you for watching this video. If you have any questions, drop us a line below.